Ackerman, the Honorable Christopher M. Goodcock, presiding Honorable Brock A. Schwartzel. All persons having business hearing draw near, give attention, they shall be heard. God save the United States, the state of Michigan, and his honorable court. Please be seated.
Welcome to the Michigan Court of Appeals. It's my honor to be sitting today with Judge Ackerman and Judge Trebilcock. I think this is this your first sitting in Lansing?
We're sitting in
Well,
Lansing.
welcome. This is the best courtroom in the land. As you can maybe tell, those who have heard me speak before, my voice is not great right now. And I can assure you it's not because I was cheering very loudly for all of our sports teams this weekend. We were just talking, it was an epically bad weekend, gave us a lot of time to study these cases. So I do want to make sure that we're focused. This is not a time to go through our brief again. We've read your brief, and this is a time really to focus on kind of a few highlights, maybe raise something that has happened in the interim between when you filed your brief and today, and to answer any questions that we might have for you. I do want to caution that in any case involving a minor or if there's an abuse situation, that we not use names, that we make sure and we use just the initials at most. And so with that, and make sure our phones are on silence. With that, we'll call the first case. Case number 1, docket number 369247, Non-Human Rights Project versus DeYoung Family Zoo.
Good morning, Your Honors.
Morning.
May it please the court. My name is Jake Davis. I'm an attorney for the Non-Human Rights Project, and therefore the attorney for chimpanzee prisoners A through G, who had their habeas corpus complaint denied by the trial court. Your Honors, because this case is admittedly unique and it's also novel, I would like to open today by telling a story that highlights the central issues in this case. Your Honors are likely unaware that there is someone who should be part of this lawsuit, but he is not. His name was Tommy. He was also a chimpanzee, and he was the NHRP's first client. Tommy's life can be characterized as little more than restrictive confinement informed by devastating traumas. Traumas which range from watching his friends and potentially family members burn alive in a house fire to watching other friends of his beaten to death with blackjacks in a cattle prod on a film set. Your Honors, when we found Tommy in 2013, he was being held in a steel mesh cage itself within a windowless shed on a used trailer lot in Gloversville, New York. Tommy's only companion at this time, aside from a few soiled blankets in his cage, was a dimly lit television outside of his already dark cell. Fast forward to 2018. We were attempting to have Tommy's habeas corpus case, one very similar to this, heard by the New York Court of Appeals. As Your Honors know, New York's court of last resort. Leave was ultimately denied in that case, but with that denial order, something extraordinary happened. A separate opinion was issued. Your Honors, for context, only a handful of times in the Court of Appeals' nearly 180-year history has a separate opinion been issued with a denial of leave. And that opinion's author, the now retired Judge Eugene Fahey, he called for reconsideration as to the legal status of chimpanzees. We cite that opinion in our briefing, as I'm sure you're aware, Your Honors. So after our litigation on behalf of Tommy ended in New York, he actually disappeared. And Your Honors, Tommy's disappearance epitomized his status as a rightless thing. His legal status as a rightless thing, that is. Without a legal right, Tommy could be bought, could be sold, he could be used, and he could be trafficked, all without the slightest hiccup. It was only later, through a number of FOIA requests, that we discovered Tommy was likely being kept at the DeYoung Family Zoo in Wallace, Michigan. And so we got to work on another habeas corpus case for Tommy. 1 week before we filed this very case, Your Honors, a case that had Tommy's name in the papers, we received further responsive documents from that FOIA request informing us that Tommy had actually been dead for nearly 2 years. We learned he died alone on a concrete slab in a cage at the DeYoung Family Zoo around February of 2022. Your Honors, Tommy died the exact same way he lived, alone, in about as unnatural of a place for a chimpanzee as might be found in this country, and invisible in his suffering to the law. Our ask of this court is straightforward, Your Honors. Issue in order to show cause so this case can properly be heard. We urge you to do so. I'll go as far as to say, I beg your honors to issue an order to show cause.
What is the relief that you're seeking?
Ultimately, Your Honor, at this procedural posture of the case, we are just seeking an order to show cause so we can have a proper merits hearing. But
I'm sorry, let me clarify. If you were to ultimately win on all the things you're asking for, not just here, what is the relief that you would want for these chimps?
we would hope that the trial court, this court, whatever court is ultimately making that decision, would find the chimpanzees have the common law right to bodily liberty, would also recognize their confinement at the DeYoung Family Zoo as an unjust confinement and transfer them to an accredited GFAS sanctuary. And GFAS stands for the Global Federation of Animal Sanctuaries.
So would this sanctuary be like, sending them to a continent where they can just roam and do whatever they want? Or is the sanctuary still an enclosed place where they have to remain?
Your Honor, unfortunately, the chimpanzees at the DeYoung Family Zoo today could not be released back into the wild. So they would need to go to a facility that respects their autonomy to the greatest extent possible. And that would be a GFAS accredited sanctuary. There are a number of them in this country. And technically, Your Honor, you are right. It is another form of confinement. But because the chimpanzees cannot be sent to the streets of Michigan or back to their native countries, this case is very similar to the case, maybe a habeas case brought on behalf of a child who cannot be released back into the wild, if you will. The child has to have someone supervise it. It has to be removed from one form of confinement to the custody of another. And so this case would be analogous to cases we cited in our brief, like Goodchild versus Foster, Ex parte Roberts, Ex parte Brooks, Walls versus Department of Institutional Services. And Your Honors, habeas corpus is inherently flexible. But I want to step back just briefly and set the scene for Your Honors. This is a common law case. This is not a case that is a matter of statutory interpretation. And that was the trial court's most fundamental error. The trial court viewed this case as a matter of statutory interpretation when it should have been viewing this case as one to be decided under the common law and the common law's principles and values. Your Honor, the trial court also made a number of other errors. I will enumerate two more for you.
So if we were to agree with you, where's the stopping point? Which non-humans, where would you draw the line?
Well, Your Honor, again, the procedural posture of this case is...
Just skip the procedural posture of this case. We fully understand that. But you're asking for something fairly extraordinary. And so I think it's fair for us to test you on how extraordinary are you willing to go? Elephants, dolphins, chimpanzees, dogs, cats. I mean, where do we draw the line if we go beyond? I mean, humans versus non-humans is a pretty easy bright line rule. But if you want us to go over that line into non-humans, where do we draw a sensible line?
Your Honor, a couple responses to that question. There can't be a bright line standard because of the nature of this case. This is a habeas corpus case, which is inherently a case-by-case assessment. But understanding that you're pushing me for a standard, I would direct you to the opinion of Judge Eugene Fahey that I alluded to in the introduction. His standard, as he stated in that opinion, was multi-step. First, the court must assess the intrinsic nature of the species at issue in the case. So you are assessing chimpanzees in this case. That assessment leads you to the finding based on the scientific information that we put forth in this case in the form of affidavits and declarations by renowned chimpanzee primatologists, including the late Dr. Jane Goodall. We have shown that these chimpanzees are autonomous. So we know they're autonomous. So once the intrinsic nature of the species is established, you then apply common law principles and values like liberty, like justice, like equality. You apply those principles to the intrinsic nature of the species. And
so it's based purely on autonomy. It's not based on, is this a being that could conceivably be part of the social contract? Because all humans conceivably could be part of the social contract. And therefore, I think that makes sense that any human being could be a party to a habeas case. But if we had 5, elephants or chimps in this courtroom, I don't know that they'd all be sitting down as nicely as everyone else in this room. So is it purely autonomy? I mean, once you get to autonomy, then you have the right to habeas?
Your Honor, we argue that autonomy is sufficient, but not necessary for the conferral of this common law right to bodily liberty. And I would actually politely, humbly push back on your remark that all humans can be subject to the social contract. That is the position that the Brahini majority and
Conceivably. They fall into a category of beings that can be part of a social contract. I'm not suggesting every human being can be part of the social contract only because, you know, bad people exist. I don't know. But that, in my understanding through history, that's been part of the habeas analysis.
well, actually, Your Honor, respectfully, children, the comatose, parents suffering from dementia, they can't be part of the social contract. But I would actually reframe that comment you made about the history.
That goes way too far. They, of course, are part of the social contract. I don't think you would want to say someone with dementia all of a sudden falls outside the social contract, and therefore society can do whatever the heck they want with that person.
Well, no, Your Honor. Today, all humans have this right to habeas corpus relief. That is beyond refute. That is a point that I would absolutely concede to you. And I would step back and I would say that the history of habeas corpus is a history of challenging unjust confinements on behalf of individuals with few or no legal rights. Habeas corpus is also a history of challenging unjust confinements. And admittedly, chimpanzees, they are different than humans, but they are not different for purposes of habeas corpus. They are relevantly similar to humans because they are autonomous, because they experience the world in much the same way that we do. They perceive the world just like you and I would if we were kept in a confinement like the confinement that they are experiencing at the DeYoung Family Zoo. And it is that injustice, that unjust nature of the confinement that allows habeas corpus to be brought into the equation and potentially be used on their behalf. And Your Honors, I would also add that the social contract really comes down to how you're defining it. Courts have defined it differently. Individuals have different understandings of it. The point I was getting at, Your Honor, previously was that the Brahini majority, the court in New York that decided the case that we brought on behalf of an elephant named Happy against us, they based that decision on this position that in order to have a legal right, you also need to possess duties or responsibilities. And so that's what I was referring to when I said social contract. But we know because of the dissenting opinions of the now chief judge of that court, Judge Rowan Wilson, the dissenting opinion of his colleague, Judge Jenny Rivera, and the opinion of Judge Eugene Fahey that I keep referring to, we know that that's an untenable position because it does disqualify certain humans from bringing the writ if you base the decision just on duties and responsibilities. Now, again, we know humans have the right to habeas corpus relief. That's beyond refute. All humans do. But the point is, the position the Brahini majority adopted, the duties and responsibilities, potentially the social contract, depending on how you define it, is not a tenable position. And this court has taken an oath to do justice and not perpetuate error. The Michigan Supreme Court has said as much in multiple cases, Montgomery versus Stephen, Womack versus Buckhorn, the list goes on. And so I would urge your honors to view this case with a fresh set of eyes and not simply adopt a position that maybe another court has adopted. Now, I want to go back to the trial court's errors. The trial court had that initial error I mentioned, which was viewing the case as a matter of statutory interpretation instead of one to be decided under the common law. The trial court also wrongly assumed that in order to issue the order to show cause, it had to determine whether or not the term person, as found in Chapter 43 in the relevant Michigan court rules, was inclusive of chimpanzees, but it did not need to make that initial determination in order to issue the order to show cause. We were entitled to the order to show cause, Your Honors. The trial court had no discretion to deny us the issuance of an order to show cause because the complaint established a prima facie case of unlawful confinement. And if you properly apply for habeas corpus relief, you are entitled to an order to show cause.
You don't have to, the court doesn't have to, you don't have to make a plausible allegation that there's a being that has the right to bring habeas action that is being confined. I mean, can you bring, would the trial court have to issue the show cause for any being, for a chimp, for a dog, for a what have you?
No, Your Honor. The only requirement of the trial court is to issue an order to show cause if you make a prima facie case of unlawful confinement. So there could conceivably be cases filed on behalf of other non-human animals that did not make the prima facie case. But because we alleged that the chimpanzees have the common law right to bodily liberty, that right is being violated because they are being deprived of their ability to exercise their autonomy, because the court is required at this procedural posture to assume the validity of our allegations, to view the allegations in a light most favorable to us. By doing so, you come to the conclusion that the chimpanzees should be relieved of their confinement at the DeYoung Family Zoo. And that is why the order to show cause should be issued, allowing the opposition to come into the case and to challenge our allegations in our complaint.
Can I ask, I guess I'm curious about a broader issue that follows up on the more broader context that Judge Schwartzel was asking is, why are all the other statutes that prohibit animal cruelty and all the safety and all of those things, why are those laws insufficient to protect the interests of the chimpanzees, wherever they are, or whatever level they are?
Yeah, yes, Your Honor. If those laws were sufficient, we would not be here today. If those laws were sufficient, the chimpanzees could exercise their autonomy as nature intended. And we have to remember that habeas corpus is a history.
So did you bring an action on behalf of the chimpanzees under any of those other statutes?
Your Honor, I am not even familiar with a statute that we would be able to bring a case under. Habeas corpus is admittedly a tool of last resort, and we do feel like this is the last resort for these chimpanzees. And I would remind the court that habeas corpus is a history of challenging confinements that violated no law. They violated no statutory right, but were otherwise unjust. That's what habeas corpus does. It can cut through whatever the positive law is at the time, and it can challenge the justice or injustice, if you will, of the confinement. We saw it in a case like Somerset v. Stewart, which is still part of Michigan law. In that case, Lord Mansfield, sitting for King's Bench, issued an order to show cause on behalf of the enslaved man, James Somerset. Mr. Somerset had no legal identity at the time. He was a rightless thing. He had no legal identity, and yet Lord Mansfield issued the order to show cause because of the injustice of his confinement. Ultimately, Lord Mansfield freed Mr. Somerset, and Mr. Somerset was able to walk out of the courthouse as a free man instead of returning to enslavement. And that is an example of how habeas corpus can cut through positive law of the time and be used to challenge the injustice of a confinement. Apologize.
But with all, I mean, you know, the brief was very well done, but with all the examples of women 100 years ago, slaves 150 years ago, what have you, those examples, you know, there's a material difference between those examples and your situation here in terms of those were all human beings, and there was no question that they were human beings. Biologically, they were human beings. You have a category issue here. So I think while those examples are interesting, they're distinguishable based on the line that I'm trying to push you on here,
Sure.
Which is, you know, if we do agree with you, you may not want to, or, you know, it may not be an issue for your side, but it's certainly an issue for us because we have to draft or come up with a standard that would apply not just here, but probably to other situations. And I'm trying to get a sense of, if we do agree with you, what standard do we apply that would keep out, I think, what we would all obviously think are not subject to habeas relief, you know, viruses, bacteria, insects, snakes. I hate snakes. There's no way. No, you know, there are certain things that rats. So where do we draw the line? Elephants, yes. Chimps, yes. Dolphins, yes. Sharks, no. Orcas.
Your Honor, if I may, I think you would need to come back to the evaluatory standard that Judge Fahey set forth in his concurring opinion. That is a multi-step evaluation that starts at autonomy. And I will say that autonomy.
I don't get this autonomy. Explain to me this autonomy, because if you win here, these chimps are not, their autonomy is not being respected. They're going from one confinement to another. Now, the conditions are better. I grant you that. The conditions might well be better, but their autonomy as a free and living thing, they're still confined.
Your Honor, they are confined, but they will be receiving highly specialized care that zoos do not even offer to their chimpanzees. And because of that care, they will be able to exercise their autonomy as close to what nature intended as possible. Admittedly, they can't go back to the wild because they haven't learned those life skills. But Your Honor, I want to come back to autonomy. You asked, what is it? Autonomy is, at bottom, a supreme and cherished common law value in this state. This court in Ray Rosebush said that the Michigan common law recognizes and adheres to the right to be free from all non-consensual physical invasions, or I think I'm mixing cases. They said to be free from all non-consensual physical, I think there was another word, but the point remains that the Michigan Supreme Court reaffirmed that language in Ray Martin. Autonomy is a supreme and cherished common law value. So for you, Your Honor, to say that species membership matters, what you are saying is then autonomy isn't that supreme and cherished common law value anymore, because the case law doesn't distinguish species.
What about deer and bear?
As far as I'm aware, sharks, deer, rats, snakes, bears, they're not autonomous. I haven't seen that science. I work in this space every day.
What's the science that establishes autonomy versus non-autonomous?
Yeah, so autonomy is defined as self-determined behavior based on freedom of choice. There are categories within autonomy, just like there's categories within human intelligence. Your honors are much smarter than me. I'm sure there are people in our society that might be smarter than you, and the list goes on. Autonomy is the same, but we know that these chimpanzees are autonomous because our experts tell us as much. Our experts, including the late Dr. Jane Goodall, have told us based on decades of field research that chimpanzees experience the world just like you and I do, Your Honors. That showing cannot be made as of today on behalf of bears, can't be made on behalf of sharks. Never heard it even suggested on behalf of snakes. And so autonomy may be an amorphous concept, I understand, kind of in the nature of this case, but Michigan common law protects autonomy. It is a supreme value. It is a cherished value. Other common law values that we mentioned in our briefing, like liberty, like equality, like justice, those all militate in favor of autonomy. Equality cases are decided on the grounds that humans should be treated alike because they're all autonomous. And so, again, to say that species membership matters is to say that autonomy just doesn't really matter that much anymore in Michigan. To say autonomy matters is to say that species membership is not relevant to whether or not, again, at this procedural posture, an order to show cause should be issued so we could at least make our case. And Your Honors, I come back to the nature of the complaint. The complaint established a prima facie case of unlawful confinement. The trial court did not have discretion to deny us the order to show cause. The statutory authorities that control the procedure of this case say shall issue an order to show cause if you make proper application. And I would point you to the opinion of Judge Levin, then writing for this very court in People v. Collins. He said, if the preconditions spelled out in the Habeas Corpus Act are met, the order to show cause has to be issued because the right to the writ of habeas corpus is absolute. It is supreme. It cannot be infringed upon. And so we are here today asking you to issue this order to show cause, to direct the trial court to issue this order to show cause so we can make our case and we can reach the merits. Because right now, although these are great questions and ones I do want to engage with, I wish I could engage longer than 15 minutes. They're premature questions.
We've gone past 15 minutes.
They're premature questions, Your Honor. The questions you're asking, with all due respect and humbly, ththose are questions for the merits of the case. Those are the questions the trial court judge should be weighing. And that is what we're asking you to recognize.
So I don't want to be a wet blanket, but there's a kind of technical antecedent question about jurisdiction, whether we have jurisdiction over a claim of appeal of right from the denial of habeas. I mean, are you familiar with triplet or any of that?
Absolutely. Yeah.
I know it's before 1990, but on that case, you had to file an original action, not an appeal, not a claim of appeal.
Right. And as I understand it, the statutory authorities allowing for the claim of appeal, MCR 7.202, A61, I believe, allows for this type of proceeding. And again, we issued a jurisdictional statement. There was no issue at that time. So I have to assume that that jurisdiction is appropriate here. Again, what we would be asking you to do is just direct the trial court to issue the order to show cause. And I hope that answers your question, Your Honor, that court rule and the relevant jurisdictional statement commentary. Your Honor, I think because we've ran past 15 minutes, I want to make sure I get in this commentary quickly. The Michigan Supreme Court said in Love v. Fallon that the courts of this state are not organized to aid in repressing innocent liberty. They are organized to give liberty. That case actually cites Somerset v. Stewart. All we are asking you is for an opportunity to see if these chimpanzees could potentially achieve their liberty. And I think that's well within the purview of this court to direct the trial court to issue an order to show cause.
Okay. Thank you. Any other questions? Thank you.
Thank you.
It was very well presented. We appreciate you coming and answering our questions. It's a novel issue, obviously. And so we've already given it some attention and we'll give it some more attention.
Thank you, Your Honors. I appreciate it.
Thank you. That case is submitted. I'll wait a moment because I figured